We are now ready to begin the RMR jury charge examination. Following is 5 minutes of dictation at 240 words per minute. Ready? Begin. Members of the jury, this case has been brought by the United States. The defendant has been charged by the United States with violations of federal law. The charges made against the defendant are contained in the indictment, which is a complete listing of the charges made by the United States. It is not proof. Since he has pled not guilty to the charges, the defendant is to be presumed innocent and may not be found guilty by you unless all of you unanimously find that the United States has proven his guilt beyond a reasonable doubt. If you are not so convinced, you must find him not guilty. The defendant is not on trial for any acts that are not alleged in the indictment. In the course of the trial, you received all the evidence that you may consider to decide the case. What you may have seen or heard outside the courtroom is not evidence and must be entirely disregarded. Your decision in this case must be made just on the evidence presented at the trial. At the same time, you are allowed to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may go where your reason and common sense lead you to find the truth from the facts which have been established by the evidence in the case. You should review and consider all of the evidence that was presented. This does not mean, though, that you must accept all the evidence as true. There are two types of evidence which you should consider. One type is called direct evidence, and that is where a witness testifies to what they saw or heard. In other words, when a witness testifies about what they know of their own knowledge through their own senses, that is called direct evidence. The other type of evidence is circumstantial evidence, which is evidence that tends to prove a questioned fact by proof of other facts. Using your own reason and common sense, you may find a fact exists or does not exist from an established fact. This type of evidence is of no less value than direct evidence, for it is a rule that the law imposes no such difference between the two. You are to decide this case without sympathy or prejudice to any party. You will consider all of the evidence in the case, follow the law as given to you by the court, and reach a just verdict based upon the evidence without regard for the consequences. It is the court's job to decide what rules of law apply in this case. I have explained some of these rules in my preliminary instructions and during the course of the trial, and I will continue to explain these and other rules in these final instructions. This is the court's responsibility, so while the attorneys may have commented during the trial and in their arguments on some of these rules, you are to be guided only by the instructions as given to you by the court. You must follow all of the rules, and you are bound to follow the rules even if you disagree or don't understand the reasons for some of the rules. Members of the jury, you are not to single out one instruction alone as stating the law, but you must consider the instructions as a whole. It is your job to decide whether the government has proved beyond a reasonable doubt that the defendant is guilty of the crimes as charged, but it is the court's job to decide what the punishment will be. You should not try to guess what the punishment might be. It should not enter into your consideration or discussions at any time. The decision you reach in the jury room, whether guilty or not guilty, must be unanimous. You must all agree. You have heard evidence that was admitted only for a limited purpose. You may use this evidence to decide whether the accused had the state of mind, knowledge, or intent necessary to commit the crimes charged. Do not use it for any other purpose. Of course, it is for you to give it such weight as you feel it deserves, but only for the limited purpose that I described it to you. The defendant is on trial here for the crimes charged, not for these other acts. Do not return a guilty verdict unless the government has proved the crimes charged beyond a reasonable doubt. The law presumes a defendant to be innocent of crime. Thus, a defendant begins the trial with a clean slate. The burden is always on the government to prove guilt beyond a reasonable doubt. It is not required that the government prove guilt beyond all possible doubt. The test is the kind of doubt which would make a reasonable person hesitate to act. Proof beyond a reasonable doubt must be so convincing that you would be willing to act upon it without hesitation in the most important of your own affairs. A defendant has an absolute right not to offer evidence because it is not up to the defendant to prove that he is not guilty. It is up to the United States to prove his guilt beyond a reasonable doubt. As you make up your mind, as you, the jury, deliberate on the verdict, do not make any decision simply because there were more witnesses on one side than on the other. Your duty is to think about the testimony of each witness you heard and decide how much you believe of what the witness had to say. You will recall that I explained to you that the defendant is charged in the indictment with 2 counts. Each of these counts is a separate crime, and you should consider each one separately and return a separate verdict for each. During the trial, you were told that the government and the defendant agreed to what the testimony of a witness would be if she was called to testify at trial. You will consider that to be the testimony of that witness as if she was present here and testified before you. You were also told that the government and the defendant stipulated to certain facts. This simply means that they both agreed those facts were true. You must accept those facts as true even though nothing more was said about them. It is your duty as jurors to talk with each other and to deliberate in the jury room. You should try to reach an agreement if you can. Each of you must decide the case for yourself, but only after consideration of the evidence with the other members of the jury. Do not be afraid to change your mind if you are convinced that you are wrong, but do not give up your true belief only because others think differently or just to get the case over with. In a very real way, you are judges of the facts. Your only interest is to determine whether the government has proved the defendant guilty beyond a reasonable doubt.